Okay, here we go. Hey everyone, welcome back to another episode of The Field Between. My name is Ahmed.
I'm Yasmin.
And today we are joined by Tina Al-khersan, who is a policy and government affairs officer at the Syria Justice and Accountability Center. Since graduating from the University of Michigan Law School, Tina has been an advocate for refugees and human rights. Tina, welcome to the show.
Thank you for having me. I'm excited to be here.
Yeah, we're excited to have you. So you recently co-authored an article published in the Yale Law Journal of International Law titled "The Colonial Order Prevails in Palestine: The Right to Self-Determination from a Third World Approach to International Law." So I just kind of want to dive right in and get you maybe to give us like the high-level summary of that article, but also get a little bit into what is a third world approach to international law and how does it differ from the dominant view of current international law?
Definitely. So the article itself approaches the history of self-determination from this third world approach to international law. And given the current moment that we're in with the ongoing genocide in Gaza against the Palestinian people, it looks specifically at Palestine as a case study, but the lessons from the article are applicable to other contexts. But a third world approach to international law, I'll begin there, is actually, I would refer to a Kenyan lawyer. His name is Makau Matua, and he has written a great piece on what TWIL is that I actually drew from his piece for the article, but is also something that I carry with me in my legal practice. So he argues that international law has allowed the West to continue to dominate over the third world, which other people call the global South, resulting in the third world viewing international law as a continued means of domination, not as a means of liberation or resistance. And so TWIL, the third world approach to international law, emerges here as a response to decolonization. Matua describes it as reactive and proactive. So he says that it's reactive in that it responds to the ways in which international law continues to be imperial, but that it's proactive in that it seeks to create a new framework going forward. What I like about this approach is that, we often think of colonialism as a relic of the past, but as this article demonstrates, colonialism was an incredibly recent phenomenon that continues to impact how the world operates today, including international law. What I also like about TWIL is that it's inherently a hopeful discipline. It doesn't see international law as inherently useless for the third world or irrelevant, but that new frameworks are needed going forward to ensure that human rights and international law is upheld in a manner that distributes power equally. And so in this article, The Colonial Order Prevails in Palestine, I and my co-author, Azadeh, we kind of cover the history of self-determination. We explain how self-determination really emerged after World War II and continues to be impacted by legal principles. And that's why people like the Palestinian people, their right to self-determination is not being heard or met.
Thank you. So the article states that self-determination is kind of the fundamental right upon which all other rights depend on, if I'm not mistaken. And so could you talk a little bit about what it actually means to have a right to self-determination and what that's looked like in different contexts, perhaps?
Yeah, so I think the way that I would state the right to self-determination being fundamental is that it is a fundamental right in international law today. So we know that it is one that is enshrined in the UN Charter and the primary purposes of the UN Charter. So it's a principle that is supposed to dictate how states interact with one another. And if we look at self-determination, it's kind of defined as having two aspects. So this is internal and external self-determination. And I think this is important to mention because a lot of people often just talk about self-determination very generally, but there is internal self-determination that essentially looks within a state and tells people that they have the right to govern themselves without interference from outside forces. And then you have external self-determination. And this is the right for people to be free from domination, from foreign interference, to determine their own political status. So the way that I like to think about this part of self-determination is that it allows people to look outside their own community and to see how they will interact with the international community at large. So, in general, self-determination is about allowing people who are usually defined by like ethnic or national identity to make decisions regarding their own political status without foreign interference. And both internal and external self-determination have a focus on foreign interference because it was really a response to colonialism. The right emerged in response to colonialism, as we cover in the article. It's a relatively recent right, at least the development in post World War II. I think what's really important here to mention is that even though self-determination, I think kind of how we talk about it colloquially, both inside the legal field and outside the legal field, it sounds pretty positive and pretty liberatory, but in reality, the founders of this, maybe not the founders, but the right was not initially imagined to be a liberatory tool.
Mhm.
So we cover in the article, Woodrow Wilson is often credited as introducing the idea, mostly on the international stage, but he himself later admits that how he phrased the term was a mistake because he didn't think that people would think that it was a right that gave them the ability to determine their political future. And so that's why we see groups, particularly in the fallen Ottoman Empire, they faced a different form of colonialization in the form of the mandate system. But all that to say that self-determination in theory is a right that gives people the ability to determine how to govern themselves.
Yeah, something I really appreciate about your article is this idea of like exactly self determination sounds so positive, and in a lot of ways it is, but that it was sort of used historically as an idea for like European powers, and that once there were powers that were or groups that were decolonizing, it was sort of like, oh, this wasn't really intended for you. A question I had that you also kind of pointed out in the article, which I thought was so interesting, was that the very kind of, and Palestine's obviously probably the most pertinent example of this right now, but the very nation states that we currently have are in many cases legacies of colonialism, right? So they're like a lot of when decolonization picks up in the 60s and even in earlier in the 50s and into the 70s, a lot of newly born nation states are just completely adapting what were colonial bureaucratic borders. And in some cases, that means that like certain ethnic groups or groups that have existed for a long time culturally sort of were cut between nation state borders. And so I'm wondering, I think it's too much to ask any one theoretical framework to solve that problem, but how does TWAIL deal with the issue of like nation states outside of the Palestine case and that kind of colonial inheritance? Like, do you think that TWAIL has to operate within a nation state framework, or do you think that there's a world in which it could kind of operate beyond it?
Yeah, that's a great question. I think so. TWAIL is just the lens in which scholars can use to approach a problem or a solution. And so I think it really depends on how the individual is adopting TWAIL in their analysis of the framework. I definitely think that there are scholars out there who argue, that the nation state is also a relatively recent phenomenon that does not privilege, like you pointed out, minority groups or ethnic groups that exist within a particular state. So I would say that it depends more so on the argument that someone is making. But I think one of the legal principles that we talk about in the paper is partly responsible for this. It's uti possidetis juris, which is a legal principle that essentially stated that the old administrative boundaries of territory became the default boundaries for that state when they achieved independence. And even when I was writing the article, I honestly had a difficult time with this principle because on the one hand, you can see the argument that okay, if you don't have a principle that allows for the continuation of previous borders, you kind of do have to grapple with what does that mean for the stability of the global order and what kind of chaos might ensue if you don't have any principle that allows for the continuation of borders. But on the other hand, I think TWAIL comes in as a helpful tool to push back against stability being the prioritized principle and to push back against the notion that borders are what lead to stability. In many cases, borders are what cause violence and instability because people do not feel as though they are able to determine their political future. They don't believe they're able to exercise their right to self-determination because they are confined within these arbitrary borders that ultimately were decided at the time of, or were decided by colonial powers.
Mm.
So there is kind of a push and pull in this argument, and I think there is some value to, the argument around stability. But I think when you're able to question where does stability come from, that's perhaps the more important question. Does it come from borders, or does it come from something else? That something else being people determining their own political future.
The argument to make former administrative states
Hmm.
or borders the current nation states applies or has been applied to both like Afghanistan, Iraq, and in those examples, we're seeing the harm it's causing because they encompass like a lot of
Hmm.
diverse ethnic groups. And in Palestine, that kind of harmful post-colonial argument, drawing of the borders is also being applied to Palestine as an argument, like a positive argument for these should be the borders of Palestine, I guess. And so I was kind of wondering if there was any sort of significant conflict in that within this principle of toil, I suppose.
I think it comes back to this idea that toil is both reactive and
Mm.
proactive. And so I think toil is just an approach that anyone can use to both kind of critique the past. And so I think a lot of our article is critiquing the way in which self-determination has been applied in Palestine historically. And then where I think the legal field often fails, and what I think your question really gets at, is this proactive piece of toil that looks at seeking to create a new framework going forward. And I felt this when I was even in law school. The law is often based on precedent. And because the law is based on precedent, the law sometimes feels inherently traditional and inherently hard to change because to justify new legal arguments, you're often having to rely on principles from the past. And so, in your example of Palestine also being a mandate and kind of the contradiction that you would think arises when you're looking at Iraq being a mandate, Afghanistan being a foreign, and the principles that are arising also basically just with these borders that were imposed by the mandate system. Um, I think Zionists don't often look at those, or there are inherent contradictions in how Zionism approaches the law and the law in Palestine in particular. And so, actually, this principle, uti possidetis juris, Zionists apply that in Palestine, saying that because Israel was the only state that achieved independence when Israel was established through the violent Nakba in 1948, Israel actually um, Israel adopts the borders of Palestine. And the scholars who argue this also argue that this would lead to more stability, that this would actually prioritize stability. And so I think that that inherent contradiction that a state that has I put state in quotes, but you can't see.
Yeah, yeah.
A state that has caused immense instability both in Palestine and in the region would cause stability through this legal principle is not a contradiction that Zionists look at very deeply, but that I think when you're outside, you would think would be very easy to see. But yeah, there's a couple things happening there. There's inherent contradictions that aren't being teased out. And then there is an inability sometimes of the law to approach these contradictions with a more proactive framework that toil requires. And even in the article, when writing the article, that was one of the hardest parts was trying to decide where do we go from here. And I think this piece in particular focuses more on like a historical narrative and looks more reactively at the past. But I mean, Palestinians have been on the forefront of more of the proactive reframing of the law, but I think all of us in the field have an immense responsibility to think more about how we can push the law forward in a way that doesn't perpetuate these contradictions that I think your question gets at.
Yeah. So I guess can you talk a little bit more about how you're talking about all these contradictions and the arguments that I suppose like Israeli jurists or legal scholars are making, using these principles for the establishment of a settler state. But um, like
Mhm.
it feels like both people, are making similar arguments for their own rights of self determination. But somehow in the international courts, it's just a balancing of these principles and then saying, well, we've come up that the Israelis just have more rights than the Palestinians, right? Like, and that's more important to us right now. And we put this, flowery reasoning around it, like it has, causes more stability, et cetera, like you just mentioned. But how does this actually get decided, and what institutions are making these decisions, and um, yeah, like what representation really is there for Palestinian people to be able to actually advocate for themselves?
Yeah, so I will say that opinion that cites that legal principle was written by the Vice President of the International Court of Justice, the ICJ, and it was a dissenting opinion,
Mm.
meaning that the majority of judges did not agree with that legal principle or the adoption of that legal principle. I think why it was notable to mention in the paper is that this argument that kind of seems inherently ridiculous reached the upper echelons of the International Court of Justice, one of the highest courts in the international community. I think what is strange in the case of Palestine is that actually the international community is, you know, in line with Palestinian self-determination, or at least at the time the article was written, 140 UN member states had recognized the full national sovereignty of Palestine. And in the ongoing face of genocide, a little bit too late, we're seeing all of these states now say that they are going to acknowledge a Palestinian state, these empty calls that have only come after an unimaginable loss of life and an ongoing genocide that is almost in its second year. So I think you're right to question where where are Palestinians' rights in all of this? And I think that's a question that Palestinians themselves have been asking, for almost a century or over a century at this point. And so I will just say that at large, the international community largely recognizes the sovereignty of Palestine and the calls for self-determination. I think what the article is pointing out is the lack of implementation of this right. And especially towards the end of our article, we talk a lot about how states have said that they haven't responded in the face of the genocide, or not in the face of the genocide, actually. States haven't responded to the calls for self-determination because the right itself remains unclear and vague, and their duties remain unclear and vague, which ultimately I think that that's not 100% true, but I think is one way in which we could be more proactive when using a TWIL approach is, okay, if scholars have been saying for decades that one of the reasons they are not responding to the inequality of Palestinian rights that we're seeing on the international stage, and that the right remains unclear and vague, how can we make that right very clear and very vague so that what felt like an inevitable outcome of, Israel being a settler colonial state that wanted to acquire more Palestinian land at the cost of Palestinian life, why have we not made that right clear and less vague for states to act before it had to get to this point?
It's just kind of following up on Ahmed's question. I think we've covered some of the like legal challenges. What do you feel optimistic about? So I know you wrote in the article, if you want to share a little bit with our readers, like the ICJ decision, if you could tell us a little bit about the significance of that. What other things are you hoping might kind of unfold in terms of international law in Palestine?
Yeah, this might not be directly answering, it is directly answering the question, but I actually, as a movement lawyer, or I don't believe that law is actually the source of change. I believe
Mm.
that people organizing are the source of change. And so even as I approach my own practice and my own writing, I think it's always very important to contextualize that often the law changes in response to movements because the law is inherently a little bit more traditional. Um, I think that it is often driven to change, as I have learned, by people and by organizing. And so I think one thing that gives me hope is the organizing that has been ongoing in Palestine, even in the face of genocide. In even the second year of the genocide, we're still seeing Palestinians from Gaza and from the West Bank, organize hunger strikes in the West Bank, and journalists, the ones that are still alive and have not been murdered by Israel, are still voicing their stories. And that gives me a lot of hope that Palestinians see the benefit in organizing, or at least feel like it is one of the only things that they can do at this point, but then also the response from the people. I do think that in the West, in particular, in the United States, in Germany, in France, a lot of these states that have largely been allies of Israel, the people are not with where their governments stand. And so that is also something that gives me hope, because the law often reacts to these movements. As we mentioned in the article, it is, and every day that we wait comes at the cost of Palestinian life. And now there's calls to occupy Gaza, which Palestinians have been saying was the purpose from the beginning of this genocide, in addition to the extermination of the Palestinian people. So I just think it's unfortunate that the law is often slow to change. And I think that is something that often frustrates me, is the lack of urgency. But I see the urgency in the people.
How do you think international law would change, and what would be the reverberations and implications if we finally recognized a Palestinian state?
Yeah, I don't know necessarily how the law would change, because I do think, well, I think the law would change in that it would be much clearer. The rights and duties that states have would be clearer in terms of what it means to believe in self-determination. So often with law, I think there is, people often ask, like, why even practice international law or believe in international law when we're not seeing kind of the positive impacts of having international law. And I think international law can have both like a floor and a ceiling. And the floor of the floor of international law for me, or the purpose of international law, at least an argument that I've heard, and honestly, I'm still trying to understand if it's one that I'm 100% convinced on, but is that the law can serve as a set of values and principles that countries all over the world, when you think about it from different backgrounds, agree on this shared set of principles. And so right now, I think that international or self-determination, as we discussed, is a fundamental principle. It's one that states agree on, and it provides us with a shared language to understand rights, to communicate about rights, and to critique rights. I think where international law could improve, and where self-determination, the right to self-determination, could be much clearer, is kind of what I would say is maybe the ceiling. I don't know that this is the right naming for this. I'm kind of thinking out loud, but I think where a lot of frustration comes with international law, and rightly so, is the lack of teeth or the implementation of these rights. And so what I would hope to see is, with the recognition of a Palestinian state, or whatever Palestinians determine is their right to self-determination, is that then there is the implementation of this right, that there is teeth kind of to this right, and that it is actually actualized. Because you can have all of these states saying that they recognize a Palestinian state, but if no one is kind of willing to back that up, for lack of a better words, then it's just, again, an empty platitude and an empty statement. And I think something that really frustrates both myself and other people, both inside and outside the legal field, is that without the kind of teeth behind the right, the people that end up being able to implement rights are those who have the most power. And those who have the most power are often those who had the most power during the colonial era.
I really appreciate the kind of your perspective of like law as being one of many tools. I think that's so helpful. Like no one tool solves everything. And also your acknowledgement that like law is created in static, right? It's not like, something that always exists. I think that the way that we're raised, at least in the US, just speaking personally, is to kind of think of this law as a thing that's like fixed in time, which we can see even in our own context, in our own lifetime, is not true. To that end, I had a question. So just like a little bit of my background, when I was doing my PhD, one of my fields was in critical race theory, which I know comes out of critical legal theory and is something that's been like highly contested, but like a really helpful tool outside of the legal field. And I wonder actually if TWAIL will become similar. How do other legal scholars view TWAIL? Like, do you find that they are interested in it, or do they kind of see it as undermining the like seriousness or the, I guess, the solidness of the law?
Yeah, it's a good question, and honestly, one I haven't engaged in as much as I wish I. I guess I've only graduated from law school 3 years ago, but even then, I remember TWIL was mentioned in one class. It wasn't even necessarily taking up space there, and I think sometimes that speaks to, how much space a certain topic is given in a curriculum says a lot about its placement. Maybe not by just the professor, but by how it's viewed at large, actually, by the international community. I do think there's also sometimes valid critiques around even having to call something TWAIL or a third world approach to international law. It could just be a approach to international law that is more critical. I think the benefit in creating this kind of framework is that, like any other framework, it allows you to, at least in for writing this article, my perspective, having TWAIL as a framework and a lens. I think the benefit was that it provided. Sorry, I'm actually just thinking about this out loud, so maybe I'll have to reframe.
No, no worries.
It's a really good question. Can you actually repeat the question and then maybe I'll go from there?
Yeah, I was just curious with like the internal dynamics of the fields, like how other legal scholars feel about TWAIL. If it's something that like my impression as someone who knows nothing about this is it seems like the kind of cool radical thing on the block, and I'm wondering if you have gotten pushback, I guess, either personally or no, if that's like something that's contended. I guess especially since it views the law kind of with a critical lens.
Yeah, I guess I would just repeat my answer here is that honestly, like I haven't gotten any pushback in using TWAIL. I do think that it is kind of more of an, I don't know that it's upcoming, but more of a fringe theory in that even when I took my international law class, like I said, it was only dedicated, only like one class was dedicated to this topic. And I think we even read actually Mikhail Matua's piece on what is TWAIL, if I remember correctly. But I do think there's criticisms of TWAIL, to be honest. I I actually feel like the criticisms that I've engaged with most are not necessarily criticisms that I think critical race theory often faces from more conservative thinkers, which I'm sure also exists in the law, with just the law being more conservative in general, not necessarily on the right or left, but actually just as a field, it is more conservative in that it relies on precedent, like we were talking about earlier. But I think even scholars from the third world or the global south have even questioned the utility of TWAIL, in that why is it necessary to categorize certain kinds of texts from certain kinds of authors as TWAIL? And I think that holds merit, and that's an argument that I'm still learning about, honestly. But I haven't been exposed to a lot of pushback in that sense at this point.
So I kind of want to bring the conversation back to the article itself, and it mentions, in addition to the uti possidetis juris, another principle that the article pushes back against is it terra nullius? So it's, I mean, I'm sure you'll explain it better than I can, but the idea, the principle that, like, in the case of Palestine, Zionists relied on to say this was empty land. And so therefore we are justified in settling it and taking control of it. And not only was it empty, but it kind of reinforces these very colonial views that the people who were there were uncivilized, and so therefore does not constitute any sort of burgeoning nation state that should be recognized internationally. Can you talk a little bit about that? Because I think I kind of mentioned it earlier, but I think one of the really popular Zionist talking points when arguing for, Israel existing and, taking over the land is that, well, Palestine was never a state. Maybe there were a couple tribes here or there, but there was no effort to actually ever become a state, and the land was like pretty much empty, which we know is bullshit. But maybe in the context of the article and kind of hitting on that principle, could you talk a little bit about that?
Definitely. So during the time of colonialization, European countries often and settlers would discover quote unquote new areas. And so these new areas they would be able to lay legal claim to if they could describe it as terra nullius, which, as you said, is empty lands. And so any lands that were uninhabited or determined as being governed in a way that was quote unquote uncivilized would be considered empty. And of course, we know even just the word civilized is kind of premised on racist notions of how societies should be governed or should govern themselves. And so this is often just a legal way to justify colonialism and the desired point behind colonialism, which is land acquisition. So by disregarding the both wishes of the indigenous people, but also their existence in some cases, settlers were able to acquire land. And so there's a scholar that I really appreciate who has written on settler colonial societies, and particularly in how they move towards genocide by wanting to eliminate the native. The name of the scholar is Patrick Wolf, but settler colonial societies by default require the native, the indigenous peoples, to be eliminated so that settlers can acquire the land. And so in Israel, we kind of see Zionists implementing terra nullius in as more of an idea. In European colonialism, it was very much a legal term that was used to lay claim to the land, and we see it in that way in Palestine. Israel using that in Palestine in that way. But I think very important is also talking about the imagination of, or the Zionist imagination, as other scholars have termed it. But we know that one of the main slogans for the creation of Israel that Zionists rely on is a land without a people for a people without a land. So even kind of this notion that Palestine was a land without a people, when I think we talk about in the article that at the time the Nakba occurred, around 750,000 people were inhabiting the land, is one that allows Zionists, again, there's an inherent contradiction. It's a land without a people, but it was, in fact, a land with a people, to ignore the reality on the ground. But we also see it applied in quite a literal way, that in a way that European settlers were using it. So in the Naqab in Palestine, there's a group of Bedouins that occupy the area in Israel now. There are scholars that have written much more in depth on this topic in particular, but I thought it was very important to mention. They use it to justify land acquisition in the Naqab today. And they argue that Bedouins, they rely, I think, on an outdated Ottoman law to argue that Bedouins are on quote unquote dead land, or land, as they describe it, not possessed or cultivated by anyone. So in this case, dead is a synonym for empty, to justify what any settler colonial society is designed to do, which is acquire more land. And I think it's important, as we discuss in the article, to talk about how, not just like British Zionists as well and imperialists described Palestinians and talked about Palestinians before and during and even today, when they talk about Palestinians at large. We have some quotes about how some labeled Palestinians as totally destitute of all moral sense. And this people did this on purpose to justify land acquisition by categorizing Palestinians as uncivilized. So terra nullius is actually in international law something that is repudiated pretty widely. It's not considered to be a principle that is, it's pretty much uncontroversially seen as, a bad legacy of colonialism, but Israel still relies on it to justify land acquisition.
So when you say that they still rely on it, I guess two questions from that. One, do they currently rely on it to justify the expansion of settlements in the West Bank? And then two, like I guess if it's like pretty widely repudiated in international law, is it still recognized in, I guess, for lack of a better word, in the right places that they are able to successfully make these arguments? Because, there's just the history of them expanding the settlements, and then, every couple of years they'll just officially and unilaterally annex them as part of Israel, or unilaterally legalize them within their own system. So I'm wondering if that terra nullius is actually recognized somewhere that matters.
So I think it's important that Israel itself isn't calling this terra nullius, and
Mm-hmm.
so in that way, it kind of avoids the legacy that comes with terra nullius, but they are using these synonyms. So you asked about the West Bank, and in the West Bank, Israel uses something called the absentee property law that we wrote about in the article. But essentially, with this law, the Israeli Supreme Court approved the absentee property law as a means to expropriate property and land from Palestinians in the West Bank. So, by categorizing certain groups of Palestinians as absent, these Palestinians were often categorically expelled by Israel. Then that property could be transferred to Israel through a certain mechanism called the custodian. So, it is very much alive and well. And then in the Naqab as well, it's not absentee property or abandoned property. It's not absentee, sorry, or abandoned property, but dead land. So there's different methods that they're using to justify land acquisition, unjustifiably, of course. But I think what is unique about the article is that it shows that all of these laws or legal mechanisms actually just fall between, or actually just fall under this broader umbrella that is terra nullius.
It sounds really valuable too that even though they aren't using the term to kind of point out that in effect they're still doing something that has been deemed illegal by the international legal community.
Exactly. And like, I think often in the legal field, we obviously rely very much on categorization of certain acts. And so the fact that these actions could potentially be, even if you don't categorize it 100% as terra nullius, that you can trace that actually it follows this legacy and that it continues this repugnant legal practice, that you can then through that way also show that this is unjustifiable, which you shouldn't have to do that, of course, but it's trying in that way to push the legal field forward through a TWIL approach.
What is there in international law that gives people protection or the right to try to fight for their rights for self-determination if no one is recognizing your right to self-determination, which again is a fundamental right? Then what avenues are there besides appealing to an international community and an international governing board that is, one, slow to act, but two, dominated by powers that just don't recognize that right?
Yeah, it's a good question. And I think it's important to identify that the right to self-determination, the General Assembly of the United Nations, it has affirmed that people who are struggling for independence are able to struggle by, and I quote, all available means. And so this has historically been interpreted to mean including armed resistance and armed struggle. And that right is also outlined in various places. And so that does exist. I think in the case of Palestine, it becomes a little bit futile when you consider, even if Palestinians were to take arms, just the uneven power dynamics that exist there, and that
Mhm.
even struggling with arms would not result in liberation, most likely, just because of the advanced machinery and the advanced weaponry that Israel now has. And that's something that I'm not sure that international law honestly predicted when it was developed, post World War II, this right in particular, and in the face of decolonialization. I think what I hope is that we can create a world in which resorting to such armed struggle isn't necessary. I
Mhm.
mean, I know that that's not the world that we live in right now, but we have seen examples where self-determination has been successful, like in the case of Namibia that is mentioned in the article. So I think while there remains a lot of ambiguity for states and how they respond to self-determination and what it means for them in upholding the right, that there still exists some there still needs to be work. I think it goes back to what we were discussing earlier, that because the right is vague and because it's unclear, it requires, at the minimum, it requires much more clarity so that states as a whole can uphold that right. Because when you're part of an international community and you're signing a treaty or you're agreeing to take part in a convention, the idea is that you're agreeing to a shared set of principles that you are going to uphold together. And I think that that's what we argue towards the end of the article is that states have this obligation. And if states are saying that they need a clearer framework, then that is something that we could provide. But it doesn't necessarily get at the heart of your question. I don't know that law always has honestly the answer.
Yeah.
Yeah, I was going to say, I think this gets back to your earlier point, which I really appreciate because I feel like we're often tempted to sort of like say that one thing could solve everything, but that ultimately the solution to the genocide in Gaza is probably not exclusively or even mostly legal at this point, but that could be an aspect of whatever comes next and that it has formed what's already happened.
Yeah, and I think where the totally understandable and justifiable frustration that people have with the law, including myself, is that the law often is positioned, whether it positions itself or is positioned by people as an arbiter of justice. When you have that framing or that legacy to uphold, even if it's a false image, I think that that's where the frustration understandably arises. Because if you have this sector that is supposed to be the place where justice is delivered and justice is not being delivered, of course, then these very rightful critiques are going to be levied at the sector. I think where I have kind of what allows me to see the continued utility in international law is seeing it as one tool of many. That is, it's a tool that is, I think, currently failing. And in post-World War II, part of the reason why all of these conventions and rights were developed was because people said, never again are we going to see the atrocities that we saw in World War II. This is kind of the first time that we're seeing a lot of these rights tested to the limit in this way in our generation and post-World War II. And so I think we're in a very critical moment where a lot of rights and principles are being tested and we're failing some of those tests. And I think the question is really the question you asked. Are we going to be able to move forward and create a better framework, or are we going to see what has unfortunately, I think, been happening in some cases, some regression?
It is frustrating because you're just like looking for an answer and you kind of just want to throw up your hands and ask, what's the point if we can't make any positive claims about, who gets to do what and like what's justified, et cetera. But I guess I maybe want to step away and ask you a little bit more, if you don't mind, about the work that you do. And you mentioned, can you just like tell us, yeah, what you typically work on?
Yeah, so I actually, before going to law school, I spent 2 years working with refugee communities in the United States, in Turkey, and in Greece. And my experience in Greece, I'm Arab, I'm actually Iraqi. I was the only Arabic speaker on the island of Lesbos. I was working more in a humanitarian capacity. And I remember feeling that I had a certain skill set and access to language, and that there was such a massive resource gap. And so I actually that pushed me to go to law school. I never necessarily wanted to be a lawyer in the traditional sense, but I wanted to make sure that I wasn't going into these kind of contexts without a specific skill set, but just because I felt called to, for lack of a better word. So I went to law school to kind of gain the skill set. And then I actually moved I spent a summer in Chios, Greece, one of the islands next to Turkey. And then I spent a year in Kos, Greece, providing legal services to asylum seekers in the detention center, providing asylum services, and then also family reunification. So I spent a year doing that, and I think actually the majority of my clients last year were from Gaza before October 2023.
Mm.
What a lot of people don't know, and I was actually working on a different article before October about how the majority of sea arrivals, particularly to the island that I was on, were from Palestine. They were being smuggled through the Rafah border, and then they would get a visa to Turkey, and then from Turkey they would take the boats to the islands. And so I kept running into these cases where people would have, a similar story, and then the law would actually serve as a barrier in allowing them to achieve any sort of um, progress with their case or any sort of justice, which I think in this case would look like release from detention, reunification with their family, or achieving asylum. And so sometimes I think when you work on case after case after case and you see the same problem, you're like, okay, well, maybe it's not direct services that I want to be involved in, but policy and advocacy. And so when I moved back to the States, I decided to work on policy and advocacy. And I also worked with a lot of Syrian clients. In Turkey, I was working primarily with Syrian refugees. And so I joined the Syria Justice and Accountability Center, and we work more on issues of transitional justice, which includes the return of refugees back to Syria and whether or not that should be taking place. But it allows me to approach the work in a different way, which is looking at the root problem and trying to influence policymakers to get at that some change at that root problem. But I also find myself questioning if policy is is kind of my theory of change. I think I'm still in the process of figuring that out.
Are there any experiences that you had in the course of all that advocacy and work that you think back to as like this is like a perfect instantiation of how wrong this system is?
This is a very niche example, but it's just something that I think about often is that, refugees are often forced to leave their home because of persecution, and usually that persecution is a result of violence, and usually that violence is caused by a foreign power. Sometimes there's a civil war and sometimes it's domestic, but even that is usually caused by foreign interference. And as an Iraqi immigrant, my family immigrated to New Zealand when my mom was pregnant with me, and then we came to the United States when I was 3. I think part of my desire to work with displaced communities is just feeling the kind of like the second generational impact of displacement. It's something that I'm kind of still working through, even as I'm now 29 years old. But all that to say, coming back to the example, I think international and refugee law in particular often looks at these individuals who have fled from persecution and asks the question, what have they fled from and are they deserving of protection? And that deserving of protection has to meet certain legal requirements. And I've heard certain arguments around, we have to have legal requirements because not everyone can be a refugee. But I think it comes back to this conversation that we were having earlier about, is there a Twail approach to borders? And I think I've just constantly been questioning a world that we've created and an international community that we've created where borders are prioritized over people. I worked with so many clients who lost family on the way to seeking quote unquote protection because they lost their lives in the Aegean Sea trying to flee. I think there's other elements of refugee law where this is something I think about often, and especially now when we talk about who is being murdered in Palestine, sometimes you'll see focus on women and children, which of course, I mean, any death is horrific. Men from the global south or the third world are often viewed as inherently dangerous, and actually in refugee law, you are categorized as vulnerable and receive more protection if you are a woman, a child, or a woman with a single woman with children. And so I've often thought about also the demonization of our men through these systems. And I know that's like a very specific point, but it's one that I'm thinking about a lot these days when we see who is allowed to be a victim. Yeah, I have a lot of examples.
Yeah. Yeah, I bet. Well, I think that covers our questions. This has been very thorough and enlightening, and thank you for definitely sticking with the conversation and kind of helping explain some of these concepts to us. Before we wrap, I know you also work on a couple of other projects, so I was going to ask if you have anything that you want to plug or just kind of tell people where to find your work.
I actually have my own podcast, but it is not a very regular podcast. But it is called The Stories of Ourselves, and I bring it up because it relates to the last conversation that we were having. But I am in the process of interviewing my family members to document and discover my own history because
Oh,
I
I
also
love
feel,
that. I will check it
yeah,
out immediately. Sorry to
yes,
interrupt, but I just love that.
no, no, no. I love that you love it because that sometimes I need to hear that to find the motivation to keep going because it's hard keeping a regular publication schedule. So kudos to you.
We do our
Um,
best, you know. We're not heroes, but
no, I think you are. So yeah, I think I only have 4 episodes, but I'm actually traveling to Texas next week, and I'm hoping to interview my grandparents who live there. So the idea is that ultimately, after I interview my family, I'll be inviting other displaced people who have experienced displacement to interview their own families. But it is a hobby at this point. But if anybody wants to listen and leave comments, that would be great. And I don't think I have anything else to add
what's the
on
podcast called again? Stories of Ourselves?
the stories of ourselves. Yeah.
Cool. Awesome. Well, definitely make sure to check out the Stories of Ourselves. I'm assuming it's available anywhere podcasts are available. Is that right?
Apple and Spotify.
Great. Well, Tina Al-khersan, thank you so much for joining us. This was a wonderful conversation. Thank you so much.
Thank you.
Thank you. Thank you for having me.
Did I go to jail? Hell no. Did I go to jail? Hell no. Did I go to jail? Hell no.
Fuck the law, fuck the law, fuck the law, fuck the law.
Did I go to jail? Hell no. Did I go to jail? Hell no. Did I go to jail? Hell no.
Fuck the law, fuck the law, fuck the law. Standing on the track, finna make the motherfucking hit. Quick to pull my pistol, quick to run up in a nigga shit. You gon' get your wig split if you ever try to fuck with me. Shouting, pimpin' MC Spade, rocking up the tracks you see. Back up on that ass in the motherfucking 9-4. Still saying fuck you to a badge, wearing stupid hoe. Coppers on my ass, cause they know I'm doing things quick. Drop me off on Hudgens where they know I'm booming yams trick. Rock spot, hot, coppers riding, trying to gap a fans. I'm the type of nigga that be shooting.